is a trademark? To put it very simply, it's a combination of words or a design or a sound or a particular kind of representation that can be seen visually. It and it is significant because it recalls and it reminds everybody, whoever sees that mark, sees that word, sees that combination, sees that logo, anything that it can be, any person who sees that name, that person should be reminded of the goods or the services that are being provided by that particular owner, proprietor, or creator, somebody who's coined that particular name. So you associate Burger King with burgers of Burger King or any other food item that can be that is popular. KFC is for the zingers and the other non-veg things that you get over there. That's popular over there. Then you get Zara. Zara is for clothing. So there are goods and then there are also services. So for example, Make My Trip is popular for providing services for your travels. So all of those goods and services, if they are condensed into one particular name or one particular logo or one particular sound or one particular color, anything, what are the different kinds of trademarks we'll study or we'll understand in the following slides. But anything that can be graphically representated and it is representative of the goods and services of the person who's using that mark, and it has some sort of a distinctiveness, which means that your goods and services can be distinguished from others' goods and services with that particular mark. For example, if I am let's say selling burgers and I'm selling burgers under the name of Burger Singh, and there's a shop in front of me, it's a franchisee of Burger King, and they're selling burgers in the name of Burger King. Of course, there is some likelihood of confusion. There was a case on this also, so study that. There's some likelihood of confusion. There's some free-loading ulterior motive that you are trying to get a free ride out of somebody else's reputation or somebody else's goodwill by copying their name in one way or the other to create confusion in the mind of an average consumer. Then that will not make your goods distinctive or make your name distinctive. So that is why it's very important for a trademark to have that element of distinctiveness, which means there is no likelihood of confusion of your brand name with somebody else's brand name. And then, of course, there are different types of trademarks that we will study. Now, these are, the essential elements of what a trademark should carry. You should know all of this from a legal point of view to be able to tell your client, anybody who comes to you for registration of a trademark, to understand whether it is even capable of being registered as a trademark. So first of all, it should be for some goods or services. What goods or services are they planning to give, or are they already involved in, and which class it will fall into? You have to understand by going through this classification called needs classification. I am writing in the chat box. Needs classification is basically a series of classes of goods and services from class 1 to class 45. You can find them, you can just random Google search or ipindia.gov.in or even at the website of WIPO, World Intellectual Property Organization. You will be able to access needs classification. So classes 1 to 34 are the classes for goods, and classes 35 to 45 are the classes for services. So you also have to identify which class is that mark falling into. For example, if they are selling food items, or they're manufacturing food items, then it can be class 9. As if they also have a restaurant, it can be class 35. If it's and it's a consultant, a general business, or somebody who's looking at marketing those business ventures and everything, then that is also class 35. So you have to study these different classes. You don't have to memorize them. You can easily access them at any point of time, but you have to understand what are the types of marks, what are the goods and services that they are planning to sell, or they are already selling, and then accordingly you have to identify which class is important, because you will be able to apply for the trademark in that particular class only. The fees that you pay for trademark registration is for every mark, every class. So for every class you have to pay a separate fees. So you can't apply for one trademark in multiple classes and pay for only one application. You have to have different applications, different kinds of services and goods are to be protected. And of course, if it is not a well-known trademark, then in that particular class where you're registering your trademark will be protected across the goods and services that are covered in that particular class. So it's very, very important for you to identify which class your trademark falls in. Can we go on to the next slide, Varun? Of course, if I'm going too fast, if you have any doubts, please don't hesitate to either raise your hand and unmute yourselves and just talk, or you can write in the chat box. Now, there are different types of trademarks. Before we understand which class it will fall into and everything, we also have to understand what are the different types of trademarks. So firstly, there are conventional marks, conventional trademarks. Conventional trademarks are like common trademarks, general trademarks that are regularly used, that are not very shocking or surprising or difficult to understand. They are conventional trademarks. So in conventional trademarks, you have to understand whether it is a word mark. Now, what are word marks? If you are trying to protect a word or a different combination of words, then it becomes a word mark. So trademarks that consist solely of words, letters, numerals or combinations thereof without any stylization or design element. So there is no text or font size or color or designs and everything, the logo, whatever the logo entails. There is nothing of that sort that gets protected. It's only the word. So, for example, if it is, let's say, McDonald's, then the M of McDonald's in the way it is written, that will not be protected if it is a word mark. I think somebody is unmuted, and there's some disturbance being caused. I don't know who that is. So, if it is a word mark, only the word or the way it is, spoken or the way it is written gets protected. So you also have to give category of marks in your trademark application. So you'll have to write whether it is a word mark or it is a device mark or it is a composite mark. So word mark will only protect the word. So if you're protecting word mark McDonald's, then it will only protect McDonalds. So McDonald's will be protected. But if you want to protect how it shows, how it looks, the logo, the way it is designed, then you go for device mark. Device mark basically it is a trademark that consists of graphical designs, symbols, logos, or pictorial representations with or without accompanying words. So if there are words also, the way they are represented, the way they are written, the font, the style, the color, the size, all of those things become important. If there are no words also, if it's only a design, then also it is a device mark. So for example, There is Nike swoosh, the curved checkmark design. Then there is Apple's bitten apple logo. Then McDonald's gold arches. Then Mercedes Benz three-pointed star, Taj Hotel, Taj Mahal device. They're all device marks. And for word marks, you have examples like Google, just writing Google, or Tata, or Infosys, or Amul, or Nike, or Coca-Cola. So the same mark can be in different categories, but for every category, a separate application has to go. For a word mark, a separate application will go. For device mark, a separate application will go. For niche classification, for combination marks, that is composite marks, trademarks that combine both word and device elements where the word and design are integrated. So they are composite marks where there's the word also and there's a design also, and you're protecting both. It's called composite mark. For example, Coca-Cola in its stylized script, word Coca-Cola, then Pepsi logo with Pepsi written there, then Air India's Maharaja, the Maharaja mascot with Air India text, Starbucks logo with Starbucks written, of course. So they are composite marks where the word is also protected and the design is also protected, but you have to identify which class they will go into, what needs more protection, and of course these are the well-known marks that I'm talking about. Everybody knows about them. But if you're registering a mark for a startup, for an individual who's just starting out, it is on a proposed to be used basis, you have to identify for their business what is more important to be protected. If they can't pay for all the applications and they can only pay for one application, then what is more important to protect, the word or the device or the composite? Because whatever you apply for, you will have the rights only to the extent of your registration of that mark when it comes to trademark registration. Of course, there are common law principles that we will try to understand, but whatever mark you're applying for, and if you get registration for that, then you will have the rights, trademark registration rights pertaining to that particular mark only. If it's a word mark, only on the word. If it's a device mark, only on the device or the logo. If it's a composite mark, then the word and the logo in the way that it is represented, and for the goods or services that are carried in that particular class where you have applied. So you have to be very, very careful in understanding that. Of course, there are different fee criterias also. So trademark applications go in this application form called as TMA. Of course, these all these all this information you'll find on the ipindia.gov.in. So TMA, the firm fees also differs for individuals or startups or MSMEs. It is 4,500 if it is online filing, and 5,000 if it is offline filing. And for companies or body incorporates, it is 9,000 if it is online filing, and 10,000 if it is physical filing. Nobody goes for physical filing these days, it's all online, and that is why it's important for you to have an account on ipindia.gov.in. So before you even think that you can advise somebody or you can register a mark for somebody, you have to sign up on ipindia.gov.in. And once you sign up, you'll have to either, if you're an advocate, you'll have to get an attorney code. The step-by-step process is given on the website. How to get the attorney code, you have to give some information to them through email, and they'll process your application. Then they'll give you an attorney code. So if you're an advocate, you can just get an attorney code and you can apply for others' trademarks using that attorney code. If you're not an advocate and if you're still a law student, there is an exam for trademark agents. So TM agents. It's either you sit for the exam or you apply for it by sending an email to them. You can become a trademark agent by clearing that exam or by them evaluating your experience and your profile, and then allotting a particular enrollment number to you as a trademark agent. So only if you are a trademark agent, or you're an advocate, or even if you're a CS, Then you can apply for trademarks of others. There are proprietors also. Proprietors, as in people who claim to be the owners of those trademarks or those brand names. They themselves can also apply by signing up and registering themselves as proprietors, but they often do not understand that it is a very complicated process. You have to go through different stages to get a trademark registered. It is not just as simple as applying for it and then letting it be. So that is why it's always recommended that somebody who has experience in trademarks or somebody who's an advocate, they only apply for trademarks because they understand the procedure. And that is why you have to understand the procedure. You have to first identify whether that trademark is capable of being registered or not. So you have to first classify it into different types of trademarks, which means classification class will it fall into, whether it is distinctive, whether it helps users or customers or clients recall their brands. If not, then of course before registering also, you have the option of suggesting that they start using or they start thinking about another brand name if they've not invested enough already on this. So for that also you have to have a very deep understanding. Now can we move on to the next slide, please? Then there are this category of marks that are called service marks. Now, service marks, they are usually used to identify and distinguish services rather than goods. So, they are, they have the same protection as trademarks for goods, but they are called service marks. So, service marks are like HDFC Bank for banking services, Swiggy for food delivery services, Ola for cab services, Byju's for education services, Netflix for video streaming services, of course. So these are service marks. Now, if we go on to the next slide, we'll understand another type of trademarks. There are special trademarks also. Special trademarks are trademarks that are distinct from conventional trademarks, because conventional trademarks are, trademarks that you often go by every day and you apply for and you understand. But there are special trademarks also, which are collective marks. So, marks that are used by members of an association to indicate membership in the association or to indicate the goods or service originate from the members of the association. Now, this can be found in Chapter 8, Section 61 to 70 of the Trademarks Act, where you can learn more about collective marks. Now, what are the key requirements for collective marks? Application must be accompanied by regulations governing use of the mark. Regulations must specify persons authorized to use the mark, conditions of membership of the authorization, and conditions of the use of the mark. So, for example, CA is for chartered accountant. It can only be used by chartered accountants. So, you have to specify all of that in your trademark application, that you're going to use CA and this is the association and these are the people who will be using it and this is the purpose for which it will be used. So there are collective marks used by members of the Institute of Chartered Accountants of India. Then there is CPA, which is Certified Public Accountant, used by certified accounting professionals. Then there's Wool Mark, used by producers of pure wool products. Then there are real estate associations, agents associations marks used by association members. These are some examples of collective marks. And then if we go on to the next slide, another type of special trademark is the certification mark. So the marks that are used to certify that the goods or services meet certain standard or quality. So for example, there is ISI mark, Indian Standards Institute, AG mark that certify agricultural products, FSSAI mark certifies food safety standards, Hallmark that certifies purity of gold and precious metals, then Ecomark, HACCP certification for food safety, etc. So all of these are certification marks. Now, when you get somebody who comes to you for consultation, you have to identify what kind of a mark is it. Is it collective mark? Is it a certification mark? Is it a conventional mark, a regular mark, or if it is the well-known mark? Now, well-known mark is very, very important. If we go on to the next slide, Varun. Now, well-known marks are defined in Section 21ZG of the Trademarks Act. You'll go through the section, you'll try to understand. But well-known marks, earlier what used to happen was that for getting the well-known recognition, you had to go to courts. Now you can simply make an application to the trademark registrar on ipindia.gov.in. The fees of that application is 1 lakh rupees per application, and it can only be done online to be recognized as a well-known mark. And then they add you to the list of well-known marks. Now, what is the protection that you get if you get registration as a well-known mark? Of course, the protection that you get is that your name, your brand name, or your logo, or whatever category of mark that you've applied into, cannot be used by anybody across classes for selling any goods or services, or in any part of the country, or even any part of the convention countries abroad also. You become recognized as a well-known mark. It is very difficult. It is not something that is easy. It comes with years and years, sometimes decades, and maybe even generations of having that brand name in your company, in your family, and then carrying it on generation by generation, and then building that level of brand value and that level of recognition that across classes, wherever any reference is made to any part of that particular brand name, only your goods and only your reputation and only your services can be recalled. That is how you become a well-known mark, and anybody else should not be allowed to capitalize on it or to exploit it. And that is why well-known trademarks have extra layer of protection, so they can easily shut down any person or any entity who's trying to infringe upon their brand name. So, well known trademark, how it is defined in the act is that it, in relation to any goods or services, means a mark which has become so to the substantial segment of the public which uses such goods or receives such services, that the use of such mark in relation to other goods or services would be likely to be taken as indicating a connection in the course of trade or rendering of services between the goods and the services and person using the mark in relation to the first mentioned goods or services. So anybody who uses that particular mark, for example, if I am using Nike to sell, earrings, even then, because I'm using the word Nike, people will think about shoes. People will think about sports. People will think about other goods that are being sold by Nike. So there is a very, very high chance of anybody who's purchasing those earrings from me to think that maybe I am also associated with the original Nike, and they have come up with another line of earrings or jewelry or things like that. And there is a very high likelihood of confusion because Nike is such a well known trademark. And that is why, even though Nike is not selling any earrings, they will still get protection if they decide to sue me, or if they decide to take any, cease and desist legal action against me. They are very likely to succeed because it's a well known trademark. They don't have to justify which class or which category or which type of trademark they own, because they are well known. So that is why it's very, very important to understand well known trademarks, and any connection or any similarity that you find with well known trademarks of anybody who's come to you for a trademark registration. you have to warn them. You have to tell them that, this is a well-known trademark, and your mark is deceptively, or it's kind of similar to this mark. It sounds like it. It looks like it. It reads like it. And there is a very high chance that your trademark application will be rejected. So please think of some other name. That is also your responsibility as an advisor, as a consultant, as somebody who's taking on the responsibility of registering somebody else's trademark. You must be able to identify if there is any crossover, or if there is any likelihood of it being in conflict with any well-known trademark. Then you have to advise them accordingly, because they have superior protection across classes. So what are the characteristics of well-known trademarks? There is extensive recognition among relevant public, and there is enhanced protection across different classes of goods and services, protection even without registration or use in India in certain cases. Now, this is another aspect that you must be very clear with, very aware of, is that registration by and in itself does not give you the right over that trademark. Registration, of course, acts as an evidence of you being the owner of the trademark. But even if you don't have a registered trademark, there are certain common law remedies that unregistered trademarks also get. Now, trademark, as you all know, is an intellectual property, right? Intellectual property means it is intangible, which means it cannot be seen or touched or felt like a real estate, like a property, like a house, like land, or those are all tangible properties. This is an intangible property. It carries a certain valuation attached with it. And if you have established that your brand name is very popular, it has been in use for, let's say, 10, 15, 20 years, you still have not registered it, that will not extinguish your rights in it. You will still have the rights that anybody with a registered trademark may have in the trademark, except that you will have to work extra hard to prove that it is your trademark. A registration certificate of the trademark acts as an evidence of the ownership of that particular trademark. But if you don't have a registration certificate, even then you can be the owner of the trademark, but you'll have to prove it. And the remedy that you will have against people who are trying to steal it from you will be called passing off. It's a common law remedy. So, if there are well known marks, even if they're not registered, but everybody knows them, even if they're not registered in India, but it's very famous world over, even then they get the protection. So, for example, Tata for automobile steel consultancy and various other goods and services, Bisleri for packaged drinking water, Coca Cola for beverages, Apple for computer electronic devices, Nike for athletic goods and apparel, Google for internet search services, Amazon for e commerce, McDonald's for restaurant services, Starbucks, etc., Bajaj for automobiles and financial services, Whirlpool for home appliances, and Intel for computer processors. They are all well known trademarks. When you get them in the database of the trademark registry, you only make it more clear for anybody who's planning on applying for a trademark that is similar to such well-known trademarks, that you will not get your registration. So it's very important. The list of well-known trademarks can also be found on ipindia.gov.in. Very important to keep checking it. It keeps getting updated. Sometimes the courts will recognize a mark as a well-known trademark. Sometimes a direct application, after the scrutiny of the application, it will be recognized as a well-known trademark and added in the list of well-known marks. So you have to be very careful that you're not stepping on the shoes of any other well-known mark, and sometimes there are some marks that are not even registered in India, but we know it's a well-known mark. So any similarity will be leading to a rejection of your trademark application. So it's very important to not have any crosshairs there. Then we go on to the next slide. Now there are some non-conventional trademarks. Now what are these non-conventional trademarks? Trademarks that are not simply word marks or device marks or logo marks or composite marks, collective marks, certificate marks, whatever else we've just studied. Those trademarks which are not conventional trademarks are non-conventional trademarks. They're not very easy and simple to understand. For example, there are shape marks. Now, trademarks that consist of three-dimensional shape of goods or their packaging, they are expressly recognized as shape of goods of their package or their packaging. They are recognized under Section 21ZB, and there are certain limitations under Section 9, subsection 3 of Trademarks Act. A mark cannot be registered if the shape results from the nature of the goods themselves or is necessary to obtain a technical result or give substantial value to the goods. So a trademark, a shape that does not directly tell you what that good is, or it does not substantially add value to the goods, or cannot is very very important for a technical result, which means it is important for a patent to be registered and everything. Those are the exceptions, and those shapes cannot be registered. But other shapes can be registered. They are three-dimensional, so they have to be graphically represented, and only the shape then gets registered as a trademark, and that kind of recognition is given under our trademark law. For example, the Coca-Cola contour bottle. So the distinctive curved glass bottle shape is registered as a trademark. Toblerone triangular chocolate bar is registered as a trademark. So you won't find other chocolates of the same shape. Then Kit Kat four finger shape. That particular shape is also recognized. It is registered as a trademark. Then Zippo lighter, the shape, the style, is also registered as a separate trademark. So you can get shapes also registered. It's a shape mark. It's a non-conventional trademark. On to the next slide, we have some sound marks. So some kinds of sounds can also be registered as trademarks. They must be represented through musical notation or sonogram to satisfy the graphical representation requirement. For example, the Nokia tune, the Yahoo, Yodel, the Intel Inside Bong, Metro, Mayor Lions Roar, and Tarzan Yell. All of these are sound marks, and they are also registered. They can be registered as trademarks because whenever you hear those sounds, you are able to recall the goods and services that are provided by that particular brand. And that is why sound marks are also registrable as trademarks. Then we go on to the next slide. We have color marks also. So certain color combinations can also be registered as trademark. For Section 21ZB, of course, recognizes combination of colors. Then there is a legal provision under Section 10. So a trademark may be limited wholly or in part to any combination of colors if registered without limitation as to color deemed registered for all colors. So you have to specify exactly which color combination you're referring to. If you get registration for that color combination, then anybody else cannot copy that color combination. For example, Tiffany blue, um, Cadbury purple, Christian Louboutin red soul, UPS brown, John Derry their green and yellow combination. These are all color marks that are also, of course, registered and recognized. Then on the next slide, we have motion marks. So, marks consisting movements or animated sequence are also registrable. For example, 20th Century Fox Searchlight Animation or Columbia Pictures Torch Lady or Lamborghini Scissors Doors. They're all motion marks, and they can be graphically represented, and they are registrable. Then we have smell or scent marks, olfactory marks. Now, a particular kind of smell can also be registered. Now, the registration of smell marks is extremely difficult in India because because the requirement of graphical representation is very difficult to meet when it comes to smell or scent marks. Now Dr. Ashwini is saying that slides are not changed. If you see, I can see the change in the slide. You can see right below motion marks on the slide that is in front of you, there is smell or scent mark or olfactory marks. Now, these kinds of marks, if you can see, Dr. Ashwini, please, let us know in the chat box. And of course, I've been talking for a very long time. So after we're done with the types of trademarks, I will be giving the floor to you to ask your questions because I know it's a lot to take. But I hope that you are making notes so you can refer to them once you go through all of these sites and these sections, provisions that I'm telling you about. And once you read them, you'll be able to recall. So the very smell marks are very difficult to graphically represent, and that is why their registration is difficult in India. Some smell marks that are registered in other jurisdictions are freshly cut grass smell for tennis balls in some countries, then plumeria blossom scent for sewing thread in USA, then cherry scent for lubricants for engines in USA. They are registered there because their requirements are different, and in India we need graphical representation of the mark, which is very difficult to do when it comes to smell marks, and that is why scent marks are not registered in India as of now. So you should be aware of that. Now, if we go on to the next slide, we will come on to trademark filing. Once you've understood what are the different kinds of trademarks, what are the different kinds of classes, of course niche classification has to be accessed, then you will be able to understand what kind of trademark can be registered and what can't be registered. And of course the e-filing process, the trademark filing process, is something that we will be discussing now. But before we do that, I like to take a 2 minute break just to understand if you are on the same page as me. If there are any questions, any doubts, please raise your hand. Please write in the chat box because there is no point proceeding if you do not follow, or if there is something that you need clarification on. So please write in the chat box or raise your hand and talk to me if there is any particular doubt that you have. No doubts? Come on, I can't that that I've made you understand everything in one go and you have no doubts. Or maybe I'm that bad that you don't know where to start. Sparsh is writing something. If you want, you can just unmute yourself and also talk directly because that will save time.
If anyone has any doubt, you are able to unmute yourself. You can unmute your mic and ask directly from me, ma'am.
So Sparsh has no doubts. Okay. Great. Now, guys, this is not the only time that you can talk. You can stop me anytime and you can write, in the chat box. Of course, we'll take your doubts towards the end of the session as well. But in the middle, if there are any particular doubts, because students for law grad difficult to understand. But for law students who may not have studied trademarks law yet, it might be a little difficult to catch up. So don't worry about it. Don't think about sounding ignorant. All of us are students. All of us are learning, and it's important to voice out your queries. And there is no stupid question. In fact, the more questions you ask, the better grasp you have over the subject in the long run. So please feel free. Now, we've learned what are the different types of trademarks. It's very important for you to understand that as a trademark attorney, as a trademark agent, before you file for trademark, so you can guide your client accordingly, that okay, because your client will not know what is a word mark, what is a device mark. Your client will not know which class it will go into. Of course, there are people who rely on chat gpt now, and they get advices from google, but that is also not very reliable, and that is something that they shouldn't do, and you specifically should not do, because I mean, you can use it for research purposes, but for you to understand what is the best way forward for your client, you will have to apply your own mind after going through all the relevant data that is available. So the very first thing that you do before you file for trademark, we have to understand the pre-registration step that you must take. Pre-filing, you must conduct a preliminary search of trademark. So for example, your client has told you that I want to register pinned baluchi, and they know that there is pinned baluchi, but they think that if we register it, maybe in this particular category they've not yet registered themselves, but if we choose the right category, we'll be able to get the name in our in our ownership, under our ownership. Then you'll have to first explain, even if it is not in the list of well-known marks. Everybody knows that Pin Baluchi provides restaurant services, and it is of course a registered mark in different classes. So you'll have to advise your client accordingly. And for example, they come up with a very unique mark. Let's say they have come up with CIST or something like that, CISC. I'm just randomly making things up because I can't use any actual names, any actual brand names right now. But they've come up with something that's extremely unique. And you've also identified which class they must register themselves in. They must go for class 36 because they are, let's say, real estate consultants, or they must go in class 41 because, or 42, because they are planning on opening some sort of a training institute or something. So and it is not a certification mark, because for that you need to have some allowances from the government, some permits from the government, or it is not a special mark, it is a conventional mark. Now you have to first identify whether somebody else has already registered for that particular name by going for public search on iindia.gov.in. Now there are different kinds of searches that you have to run. First will be, of course, on the trademark website, ipindia.gov.in. You'll go for public search. You'll search for the word mark of the exact same word, which carries different kinds of searches. There's a matches with search, there's a contains search, there is a starts with search in word marks, that are you looking for any name that starts with this particular name, or contains this name, or matches with this name. So you have to run all those searches. Then you have to run a phonetic search. Phonetic search is also something you'll find on the ipindia.gov.in public search. I'm writing all of this in the chat box for your convenience, so please make a note of it. Make phonetic search to see if there is any other mark that sounds similar to that mark, because even if there is a phonetic similarity, your application will be rejected. So you must do a phonetic search also. If it pertains to a logo or a design, or graphical representation with certain stars or animals, or shapes that are forming a part of the logo, then you do a Vienna codification search also. Now, what is Vienna code? Vienna code is basically just different classes like any classification, but Vienna code has different shapes and symbols and designs. So, if there is any other mark that is already registered or that is applied for, which carries those designs or those shapes or those kinds of logo that your client is trying to get registered, then there will be an objection from the registrar. So you'll have to run a Vienna codification search also. Again, you'll find it on public search option in ipindia.gov.in. So once you've run all of these searches, if you found nothing, there is no similar mark, you also run a Google search. We'll see in our slides when we talk about landmark cases that even if there is a domain name that is registered with the same name or a similar mark, even that can be a problem for your client. So for example, they are looking for registration of Surti, and there is already a domain name certi.in or certi.com or certi.uk or anything like that. So once you run a Google search, you'll find multiple other brand names that are similar to or exactly identical with your brand name. Then it is a problem. So even if you can't find it on trademark registry, you find it on a Google search, it is a problem, because it whenever they find out, if they have a more popular presence on social media or online also, and you start using it, even if you have prior registration, even if you get registration of the trademark, they always will have their passing of remedies. They will be able to sue you because they'll be able to show this thing called prior use. So there's a major conflict in our trademark laws between prior use and first to file. Now, prior use means that you have been using that particular brand name for a very long time, though you did not get it registered. So, when you're filing an application for it, whenever you file an application for it, you have to file a user affidavit. A user affidavit will basically allow you to say on oath, under oath, that I've been using this mark for so long and these are the supporting documents. For example, I have been using this mark for 10 years now, and this is my invoice for from 10 years before, with my mark, my name on it, my brand name on it, which proves that I have been using it for so long, even if it is not so popular on social media and everything. So you have to give proof of prior use. For that, you have to file user affidavit along with your application if you're claiming prior use. If you're not claiming prior use, then you have to select this option called proposed to be used. Now, for all of this, remember you have to have login credentials of ipindia.gov.in. You go to the option of comprehensive e-filing and you sign in, and then you get the option to file. And when you get the option to file, you can see the forms and the application forms and everything, and you have to fill in those details. So they'll ask if you are claiming prior use or if it is proposed to be used. If you can't find any evidence of prior use, you have to give proposed to be used option. And if somebody else claims prior use and they apply later, your application has been filed first, but they apply later, but they are claiming priority. They are saying we have been using it for a very long time. Then they will get an upper hand. So that is why when you look at it from a larger perspective, from a broader perspective, you will know at the time of applying only that this mark may run into difficulties later, so it's better to change it. So if you find any similar or identical mark which is popular on social media or as a Google search, if you can find it everywhere for different kinds of goods or services, please try to change that brand name if you still can change that brand name. Of course, if you've been using it for a very long time and you can show priority, then you go for it. So you have to advise your client accordingly on a case by case basis. So Google search you do, phonetic search you do, Vienna codification search you do, public search you do, and once all of your comprehensive searches have been done and you find no similar or identical mark, only then you go on to filing. You can file as a proprietor, as a trademark attorney, as an agent, as we discussed, after your preliminary search. Now there are different branches of trademark registry. There is one in Delhi, there is one in Mumbai, there is one in Ahmedabad, and there is one in Chennai. So you have to identify where is your territorial jurisdiction. Now, territorial jurisdiction means where, which trademark branch will you be applying your trademark to. And all of this is usually automated. You just have to put in the address of your principal place of business. You'll have to put in the address of the proprietor, where they are registered. If there is an individual or a startup or an MSME, you have to give documentation support. You have to give their principal place of business. Accordingly, your jurisdiction will be decided. All the registration certificates come from Mumbai only, but this is just for their internal examination purposes. Different jurisdictions are placed. So, as per your principal place of business, or if there is no principal place of business, then as an agent, what is your address for service? And then according to that address the jurisdiction will be decided, and that also gets automatically filled on the application form, so you don't have to worry about that, but you have to know what is the principal place of business. Then you have to identify whether it is proposed to be used or there is a prior use. If there is a prior use, you file for user affidavit. For that you'll have to draft user affidavit. Now I will give you another trick. Remember this, as a fresher, or as somebody who's just starting and you don't really know how these things are drafted and everything, you have to do nothing but just go to IP India, do a public search. Any trademark you apply in any class and you do a public search. And once you get the trademark application number, you copy it, you go to trademark status. So check trademark status on ipindia.gov.in. You put in the application number, and you'll find that detailed application over there with all the uploaded documents and all the correspondences that have happened between the registrar and the applicant. And you'll be able to find different kinds of documents like a reply to the examination report, user affidavit, how it is filed, evidence, how it is given, if there is any opposition and everything. We'll study that later on, but you'll be able to find all of these documents. So study those documents, read those documents. They will serve as your draft or your basic foundation to go on to then draft on your own, to understand what are the kinds of objections that are raised, what are the kinds of replies that are given and things like that. So it's very helpful. So always whenever you get time, do this exercise, read as many drafts as possible. You'll be able to learn a lot from that. And then whatever other required documents for your registration, it depends of course on case by case basis, and the filing fees I've told you already. So you have to have a clear representation of the trademark. If it is a logo mark or a word mark or a device mark, if it is a logo or device mark, you have to have a very clear photo of the logo and everything. You'll have to upload it. Then applicant details, you'll have to have what is the name, address, nationality, legal status as an, are they an individual, MSME, or a startup, or a body incorporate, or a partnership firm, whatever. That is their legal status. You'll have to specify that. Then goods or services for which the trademark is sought, with the class details. So for that you'll have to study the niche classification. What are the category of classes? For example, right now your client is only seeking protection for coffee. They want to use a brand name for serving coffee in their cafe. But you know that eventually, they might also serve muffins, they might also serve some desserts, some food items, and everything. So, whatever you think your client will expand into, you also include those goods or those services in your application. So, whenever it gets registered, you have protection for those goods and services also, and you can use it. You can give proposed to be used. Detail over there. Then there has to be a signed power of attorney if it is an advocate who's filing. So power of attorney has to be in your favor. Like I told you, you can go through different applications. You'll see power of attorneys also. It's not rocket science. You can draft accordingly. It has to be notarized, and there has to be a stamp paper of 100 rupees and everything. So, all of this can be figured out. Then priority documents, for example, if it's a convention application, so there are convention countries that recognize trademark registration in other countries, even though there is no registration in that particular country. For example, a trademark that is registered in US will be recognized in India. For that, you'll have to file a priority. So you'll have to specify it's registered here. This is a registration number, and we'll give in India also we'll give reciprocal priority to that particular mark. Then, if there is an international application, it has to go through Madrid Protocol. So you have to study that, and that is also not very difficult to understand. Madrid Protocol applications, all the forms and everything you'll find on comprehensive e-filing. And then, once the application is done, it has been applied for, you can use the symbol TM. TM symbol means that the application, that the trademark has been applied for, even though the registration has not yet been granted. Then we move on to the next slide. Now, these are the during registration steps that you have to be, wary of. Once your application is filed, it is filed online. Physically, also you can file it. They'll charge you more. You'll have to get a lot of papers in order. So it's generally not recommended. E-filing is the easiest way out, and all the payments you can do online. So it's very comprehensive in that manner. So once you filed and the application has gone, you'll get a formality check pass or a formality check fail. Formality check is basically to see if your documents are in order, if the names and all the details that are required are there or not. If they're in order, you'll get a formality check pass. If they're not in order, you'll get a formality check fail, in which they will give you a show cause hearing, ideally, or they will give you some time to file a reply. They'll say that, okay, you file a reply within 30 days, or you give us this document within 30 days, and we'll then process your application accordingly. If you do not comply within 30 days, you're not giving a reply, or you're not appearing for the show cause hearing, all of this is online, mind you. Remember, all of this is online, so you can do it from anywhere. But if you're not complying with the timeline, then they can treat your application as abandoned. Then, once it goes through the formality check pass stage, when it has been passed, then you go to the stage of examination report. Now, examiner or a registrar will examine your application, and they will give you an examination report. Now, that examination report usually carries objections under Section 9 of the Trademark Act or Section 11 of the Trademark Act. Broadly, they will say that somebody else, that your mark is not capable of distinguishing your goods from somebody else's goods, or it is directly talking about the goods or services that you're going to provide for. For example, if I'm going to sell toffees, and my the trademark that I've applied for is toffee, then there is no distinctiveness, then that will definitely get a Section 9 objection. Then, if it is offensive, if it is misusing, or if it is using some symbols or some emblems that are not allowed to be used, or if it is capable of hurting religious sentiments, then Section 9 objections will follow. If it is similar to or identical with any other mark that has already been applied for in that particular class, then it will attract Section 11 objection. You'll go through the sections, you'll try to understand different kinds of objections. You'll see different kinds of examination reports, and mostly they'll carry either Section 9 objection or Section 11 objection, or both. So what happens after that is that you have to then justify your application, and that is why I say that it is very important for you to be a lawyer for applying these for these trademarks, because you understand the legal nuances and the nitty gritties that go into these replying and everything. So you have to be very technical in your approach. So you have to file a reply to the examination report within 30 days from receipt of the examination report. If again you do not reply, then your application can be treated as abandoned. Once you have replied, you have said, you have explained that, you have to look at my mark as a whole. It is not descriptive of the services or the goods. It is not offensive to anybody. It is distinctive. It is capable of distinguishing my goods from others, and it is not identical or similar to anybody else. Now, you remember, even if somebody else has filed before you have filed and their trademark is conflicting with yours, you will get an objection of section 11. So you'll have to justify how it is not identical or similar to that particular applicant's mark, even if they don't have a registration yet. So even if they've just applied, you can get a section 11 objection. So you'll have to justify that, there are a lot of case laws that say that, the mark has to be looked at as a whole. You cannot dissect it just to manufacture, fabricate some similarity or some confusion that may be caused. So you'll have to justify that in your reply. Again, you can go and see others' replies and see how people basically navigate or maneuver their way through these kinds of objections. Then, if the examiner is not satisfied with your reply, they'll issue a notice for show cause hearing. Show cause hearing will be when you will be then asked to appear. Again, you can appear online, and you'll have to explain your reply to the registrar how their objection should be waived. And after the show cause hearing, if the registrar is satisfied, they'll accept the trademark application and they'll issue the notice for advertising that particular application. Now, once it goes for advertising, there is this concept of trademark journal. Trademark journals is also something you can find online on ipindia.gov.in. And once it is advertised in trademark journal, and there are no oppositions that are or no objections that are received from third parties within 4 months of the advertisement, you will get your registration certificate. So it is not a simple process, it is not easy, it is not as good as applying and getting your registration certificate. It goes through various stages of scrutiny, as we've just discussed. Then we move on to the next slide. If god forbid, you also get objections from third parties, then there will be these proceedings called opposition proceedings. Now, mind you, I am not, because it's a short session, we've already crossed our time limit. I'm not including every kind of objection or every kind of proceeding that can be initiated at the registry level. These are the broad kinds that you must be aware of. But once you go through the website and everything and the law, you'll understand there are different other proceedings also that can, be initiated at the registry level. So during registration, if anybody who's aggrieved, so people and big firms and lawyers, they conduct this activity called trademark watch. That is something that I would also recommend for you to do after your mark is registered. Now, what they do is they go through all the journals and they see if there is any mark that is similar to their client's mark, which has already been registered in different classes and everything. So those 4 months are for any third person who's aggrieved by that advertisement to object to the registration of that particular mark. So that is why, don't tell your client once it has been accepted and advertised that okay, now you'll get your registration certificate. No, there will be another layer of scrutiny for 4 months. If they're lucky and they do not get any opposition, then they'll get their registration certificate. If they get an opposition, then a notice of opposition will be served upon you. Again, all of this is online. You'll have to file a counter statement. You can see other counter statements to see that how people are justifying their mark, how they challenge the locus of the opponent or the motive of the opponent or the fact that there is no similarity and there is no the allegations that are leveled against them are not true. It depends on case by case. So they'll have to counter that. For that, they'll have to file a counter statement. After the filing of the counter statement, the opponent will have to file evidence affidavit in support of their opposition. So they'll have to file supporting documents, and there'll have to be a detailed affidavit that has to be filed by the opponent under oath. Once that evidence is given, then the applicant will have to give evidence in support of the application. And once the evidence stage is closed, a hearing takes place, opposition hearing takes place. And after the opposition hearing takes place, if the registrar is satisfied that the application should move forward, they will accept it and they will register it. Otherwise, they will reject it. So, this is also another layer of scrutiny that you must be wary of. There can be opposition proceedings. Now, we go on to the next slide. Now, grounds of refusal, as I've already discussed, these are the grounds of refusal at the registrar level. So the objections that can be raised by registrar, section 9, they can tell you that the mark is devoid of distinctive character, it is descriptive, it is generic or common trade terms. So for example, recently there was this wow momos controversy, that wow word is a common word, it's a general term, so it cannot nobody can claim exclusive rights on the word wow. So those are the kinds of generic or common trade terms and marks that are contrary to public policy or morality or are deceptive. Now deceptive has to be understood very very widely. You have to know that what is deceptive. There has to be an intent of piggybacking on somebody else's goodwill or somebody else's reputation, and that is how your mark becomes deceptive. So if it is deceptive, it will attract a section 9 objection, otherwise it will attract section 11 objection, where they say marks are identical or confusingly similar to existing registered or pending marks, then likelihood of confusion with earlier marks, and then there are well known trademark conflicts. So all of those conflicts will attract section 11 objection. So that is why it's very important to do a preliminary search, as we discussed, so you can avoid these objections. And even if these objections come, you already have a very good solid defense to counter these objections. Now we move on to the next slide. Now, once the registration is done, if it is done, if you're lucky enough, and all of this will take easily, 1.5 years. This does not happen in a couple of months. Of course, now we have provision for expedited processing of the applications. So we can file this form called TMM, but there is an additional fees for that. So 20,000 rupees will have to be paid. If over and above your application fees of 4,500 or 9,000, depending upon the type of applicant. So once you pay that amount, then your application will be processed in like 2 to 3 months. That does not guarantee registration. That only guarantees faster processing of your application, and even then you can get objections. So well, if you go for expedited, in my experience, you get registration in say about 4 to 6 months, provided there are no objections or oppositions. But if there are objections, oppositions, it can take any time from 1.5 years to 2 years, 2.5 years. And if it's a regular application, even then it'll take 1 to 2 years minimum. So your client should be aware of that. Now, then, once the registration happens, the registration date will be with effect from the date of the application. For example, you applied today, but you're getting your registration certificate 2 years from now. Your registration will be effective from today, even if you get the certificate from 2 years from now, and your registration will remain valid for 10 years. Once you get the registration, only then you are allowed to use the symbol R with your brand name. Before that, you can only use TM if you've applied for your trademark. Then after 10 years, you'll also have to get it renewed. So post registration is on the next slide. The post registration compliances, or the post registration steps that you must take. First of all, you must renew. If after 10 years, your mark is pending renewal, you must renew with, 1 year before it is going to be pending for renewal, or 6 months after the renewal date has expired, you get the grace period to get it renewed. Then, if it gets abandoned or if it gets cancelled because you fail to renew it, you can also apply for restoration. Then you have to maintain the use of the trademark. For example, if you've gotten a registration of the trademark but you're not using it for a continuous period of 5 years, then it can be removed from the register of trademarks. So you must maintain the use and you must tell your clients about it. And then, of course, like I told you, there is trademarks watch that you can conduct, which means you can go through upcoming journals, see if there are any similar or identical marks to your registered trademark. And then, if you find any, then you file for opposition and you oppose it or you object to it. And for that, you have to be very, very proactive. A lot of the big clients with big brands, they usually do go for this service. But if a lot has gone already into the building of the brand name, and your client your client's entire business relies on that brand name, and you've gotten that registration after so much hard work, you must conduct trademark watch to ensure that it is not infringed upon, and you're taking proactive steps to prevent any infringement. Now we go on to the next slide. Now, these are the important forms that you will find on the website. Like I told you, there is TMA, that is the application for trademark or registration of trademark. TMM, that has a lot of purposes, but mainly it is used for correction or amendment of a trademark application. Now, correction also goes to a certain limit. You can correct clerical errors. You can't correct the entire nature of the application. So you'll have to either, if you want to change the trademark agent or attorney, then you can file TMM, or you can, if there is a spelling mistake or address change or things like that, you can file TMM. For expedited, also you can file TMM, but the fees will vary, of course, for different services. If you want to make a correction, a minor correction, then it is 900 rupees. If you have to, file for expedited, it's 20,000 rupees. The fees also keep changing, so you have to be aware and updated on the website. Then TMO is the notice of opposition to registration. TMR is application for renewal of trademark. Now this is broad, okay? This is very, very broad. This is not, these are not all the forms. This is broad. These are the forms which are used commonly. And then TMM for expedited, like we just discussed. Now on the next slide, you will see what are the rights that you get with trademark registration. Like I told you, registration is not mandatory. There are remedies for those also who have not registered their trademarks, but it gets difficult for them to prove that it is their trademark. So, with registration, you get exclusive right to use, which means that your goods, your services are protected, and you have exclusive right to use a trademark for the registered goods and services. And if anybody else uses your trademark for those goods or services, you can file for infringement. Infringement suits can only be filed by registered proprietors of a trademark. But if your trademark is not registered, somebody else is infringing, then you have the common law remedy of passing off, which is the long format, which takes longer to even prove that it is your trademark. With the registration certificate, at least you bypass that level. You don't have to prove that it is your trademark. You have a registration certificate. That is evidence in itself, and you have the right to stop anybody from infringing it. Then right to prevent use, like I just said. So power to retain, restrain and forbid every other person from obtaining registration or using the same trademark or any identical or confusingly similar one. Then you have remedial rights to obtain relief in cases of infringement, and transferability. So you also get the power to license or assign or franchise your trademark if you have a registration certificate. So it's very, very, very important, especially in today's day and age. Then we go on to the next slide. There are some special considerations for foreign applicants. Um, where foreign applicants, if they want to register in India, they have to have a local representation. So they must appoint a local trademark agent or attorney to represent them before Indian Trademark Registry. Direct filing from overseas is not permitted. Then Madrid Protocol designation. I will not go into the history of why it is called Madrid Protocol and everything. You can study that on your own. But you have to understand that there is a Madrid application also that gets filed. So India is a party of the Madrid Protocol, and foreign applicants can designate India through an international registration, though direct national filing may offer more predictable timelines. So they can apply through Madrid Protocol also. Once you get a comprehensive e-filing login credentials, you'll see there is a portal for Madrid applications also, where you can do international filing. And then there is convention priority, like we discussed. So if you're a convention country and you are already registered in a convention country and you give those details in your application, then you will be considered as having prior rights, and your application will be processed faster, and it will prove as an evidence that you have priority over the mark. So you'll be registered in India also, being a convention country. Then on the next slide, I have chopped down some key takeaways for you guys. Of course, you'll also have your own takeaways and you'll have your own doubts and everything. But what I think you must retain after this session is over is that in India we have a first to file system. So India operates primarily on a first to file basis, though prior use can be invoked defensively. Early filing is crucial. So, like I told you, you can get Section 11 objections only, even if somebody else has applied for that trademark before you did, even if they don't have a registration yet. So, we have a first to file system. Then importance of search is very important. People neglect it, they don't understand it, and that is why people who apply directly or through CS are not able to navigate through these objections or oppositions or hurdles, obstacles that they will face later on in their applications. So that is why it's very important to conduct a comprehensive preliminary search, which significantly reduces the risk of objections and disputes. Then there should be timely compliance, so strict adherence to statutory timelines. 30-day response period, 4-month opposition period is essential to avoid abandonment, and perpetual rights. So trademark rights can be renewed every 10 years, and they can be extended till perpetuity. There is no upper limit for how long you can keep on renewing the trademark. Then active use is required. Continuous use is important. If it is not in use for 5 years continuously, then it can be treated as cancelled. Then public notice functions of publication in the trademark journal serves as a constructive notice to the public and triggers the opposition period. So you must be very wary of that. You must keep a trademark watch also. Then multi-stage process. So you have to understand each stage from search through registration. It helps in strategic planning and client advisement. So it is not very easy, for you to just apply and get your trademark. This was about trademark registration. Now, quickly, we'll go through some landmark judgments that, of course, I'll briefly tell you about, and you can make a note of them and you can see on your screens the brief summary of those cases and study them for your own understanding. Then we'll take up your doubts and queries. So if you can go to the next slide, Varun. We have a landmark judgment called Cadila Healthcare versus Cadila Pharmaceuticals. In this, what Supreme Court laid down was basically the fact that you have to be more careful when it comes to pharmaceuticals. You cannot deceive or have any likelihood of confusion in the minds of general public when it comes to pharmaceuticals. There has to be an extra layer of protection when it comes to trademarks that pertain to pharmaceuticals. So this is a 2001 judgment. In this, both parties, they were pharmaceutical companies, Cadila Healthcare and Cadila Pharmaceuticals. And Cadila Healthcare had the trademark called Falcijo for anti-malarial drug, while Cadila Pharmaceuticals had Falcitab for a similar product. But what the principles that were established in this judgment were that There has to be a higher standard for pharmaceutical trademarks. There has to be a multi-factor test for deceptive similarity. So you have to understand what is deceptive similarity, and for the standards that have to be applied for it, and they have to be higher when it comes to pharmaceutical products. So you have to understand the nature of the marks, whether it is a word mark or a label mark, composite mark. It all boils down to the likelihood of confusion it will create in the mind of an average human. So a potential customer, a potential consumer, what is the confusion that it can create in their minds, with average intelligence? Very, very, very basic. So if it is likely to produce or create any confusion, then it should not be used at all. So then there is degree of resemblance, phonetic, visual, structural nature of goods in respect of which they are used, similarity in the nature, character, and performance of goods, and class of purchasers who are likely to buy the goods, mode of purchasing the goods, any other surrounding circumstances. So these are the different tests for identifying deceptive similarity. Now this will come in handy for you even at the stage of show cause hearings in trademark registry, because a lot of the times they say that this is deceptively similar to another mark which is already registered or which is applied for, section 11 objection that you may get. So you can navigate through those by applying these tests and say that no, there is no deceptive similarity, or to defend your application basically. Then in this judgment it was said that public interest is of paramount importance. So if there is any deceptive similarity that can cause harm to the public, that should be prohibited. So what was and dominant part test? Dominant part test is that you are not dissecting the mark to see which part is similar and which is not. It has to be taken as a whole. You have to understand what is the dominant part of the mark. In this case, the dominant part was falsi. FALCI. So falsigo and falsitab. So there was a dominant part which was directly in conflict with the other, and that was likely to cause a lot of confusion, and that is why the Supreme Court ruled in favor of Cadila Healthcare, finding that Falsitab was deceptively similar to Falsigo and granted permanent injunction against the respondent. So this is a very important case. On the next slide, we have Satyam Infoway versus Sifinet Solutions Private Limited. Now, in this, interestingly, what like I was telling you, what had happened was that they had a trademark brand name Sify. Now the defendant, the respondent also started using Sify.com, Sify.net, Sify, etc. with double F. So there was a domain name infringement that was also presented in this case. So for the first time, Supreme Court held that domain name is also an intellectual property, and any infringement in domain names can also be considered as infringement of trademark. And now this judgment provided that the legal framework for protecting trademarks in digital domain and established that traditional passing of principles apply to internet based commerce. It has become the cornerstone for domain name dispute resolution in India. So that is why this judgment is very important. You can note down the names of these judgments, and of course you can go through them in detail later on. Then the next landmark judgment is on the next slide, which is Milmet Opto Industries versus Allergen. Now, this is a critical judgment on prior user rights and the interplay between registration and common law rights. So, Allergen Incorporated was a USA based company. It was the worldwide user of the trademark OcuFlux for ophthalmic products but had not registered in India. Now, Milmet Ophtho Industries obtained registration in India for a similar mark for pharmaceutical products. Allergen filed suit for passing off and cancellation of registration, and they won, even though they did not have registration in India. Why? Because they had prior use. So, in this, the key principles that were established were that common law rights override registration. Even where the defendant has obtained registration, the plaintiff with prior worldwide use and reputation can succeed in a passing of action based on common law rights. Now, this established first in the market doctrine. So or prior user enjoys superior rights. That is why if we have a trademark but we have been using it for a very long time but we are registering it later, if we apply for it saying prior user and give a user affidavit, we have higher chance of getting our application accepted. Now, in this, the Supreme Court held that allergens prior worldwide use created superior rights and granted injunction against Milmet despite Milmet's registration in India. And this has the principles laid down in N.R. Dongre and established that registration does not defeat the right of a prior worldwide user with established reputation. Now, the next slide talks about recent trends. In recent trends, there's a trend of common law rights superior to registration rights. So, Supreme Court in S. Sayyid Muhyiddin established that registration merely recognizes pre-existing common law rights and does not create new rights. The court held that rights of prior user are superior to registration rights, and even a registered proprietor cannot disturb or interfere with the rights of prior users. This principle has been extensively applied by high courts in 2023 to 2025, and that is why when you're looking at your trademark applications, if there is no user affidavit that you can file and you are with a common law search or a Google search, you're able to find somebody else who's been using that exact same mark for a long time even though they're not registered in India, but they're pretty popular. Then you stand the risk of getting your application rejected because prior use is recognized a lot more now than it was earlier also. So even though we are a first to file system, but first to market doctrine has also been recognized. Then we go on to the next. So family of marks and registration rights. So in Modi Mandi Pharma Private Limited, it was held that if there are associated marks, for example, one person has registered for multiple marks using the same marks for different products and different services that they're expanding into, then their family of marks will also be considered. Then on the next slide we have Crocs versus Liberty shoes. In this, passing off and design registration was talked about. So passing off action was considered to be maintainable, and there was no something more requirement for passing off because it was a well-known brand. Now, then there was a case of Carlsberg Brewery. So the court analyzed this case and they said that the distinction in Carlsberg is between mere trademark use, which gives rise to infringement, and use of registered design as trade dress. And then there is commercial use of the registered design not merely as a trademark but as a larger trade dress or packaging, and it can support a passing of claim. So even if there is a trade dress, then also trade dress as in how it is packaged, how is it presented, and there's no actual trademark registered, even then it can qualify for a passing of claim when it comes to popular marks. Then there are also concurrent rights. So section 12 of your Trademarks Act will tell you about concurrent rights, which means that there is two people are using the same name concurrently for different services and different goods, and they can reach a certain agreement regarding that. So both design infringement and passing off actions can proceed independently. If design infringement claim is weak, plaintiff does not have to face adverse consequences in passing off action. So here, if the concurrent use of section 12 is not qualified, there's no agreement that can be reached, then there are two different legal remedies that have been taken against the same person: design infringement and passing off. So just because design infringement is proved, it doesn't mean passing off will be proved. Just because passing off is proved, it doesn't mean design infringement is proved. So every action has to be taken independently and cannot be used one for the other. Then, of course, there has to be on the next slide. You'll see there is territoriality and concurrent registration. So, where you're using the mark is also very important. This case is VIP Industries versus Carlton Shoes. So, in this division bench judgment had come on 1st July 2025, where the principles established were that no infringement between co-registered proprietors. So there are two proprietors who are co-registered and they hold registration for identical similar marks. Neither can maintain an action for infringement against the other. And passing off is independent of registration. Passing off is a common law remedy. So if there is goodwill established or there is misrepresentation, there is damage or to business or goodwill, then there is a passing of remedy that is available. Then territoriality also has to be looked at. Rights to protect intellectual property are exclusively territorial. So you have to show that your mark or your brand is being used in that particular territory, and there is a likelihood of confusion, and that is how your mark is being infringed or there is a passing off of your mark. Then there has to be a distinction between infringement and passing off. So just read it carefully. We don't have a lot of time. I won't go too deep into it. Then on the next slide we have prosecution history estoppel. This is Mr. Shantaba versus Miss Anna. It's a 2023 case in which they said that if there is a prosecution history, which means that you have filed for cases against this person before and you've lost, then you can't seek infringement later and say that you didn't know this person was using a mark. This person has been using your mark. You have acquiesced to it by not taking timely action or by not doing anything to stop that person while you still could. So there is an estoppel against you from now taking action. Now, on the next slide, we have a case pertaining to trademark examination and opposition. Syncom formulations versus Yusin Pharmaceuticals. It is a December 2023 judgment where they addressed infringement of registered trademarks and copyrights in pharmaceutical products, and the court granted injunction where plaintiff established valid trademark registration, copyright in artistic work, infringement by the defendant in export market, and strong prima facie case of infringement. So all of these ingredients had to be met, and then relief was granted in their favor. Then on the next slide, we have key cross-cutting themes from recent judgments that you must make a note of. That common law rights versus statutory rights. So recent judgments consistently uphold common law rights over registration rights. So you have to be very careful when you're applying for a trademark. Then, if there is an honest concurrent use, Section 12, then an agreement can be reached, and there cannot be any case against the other party if there is an honest concurrent use. Then this defendant has to establish long-term use, no evidence of dishonest adoption, plaintiff's acquiescence. Then Section 33, protection against acquiescence applied. Then well-known trademark declaration, recent cases have clarified that courts have concurrent jurisdiction with registrars to declare matters as well as well-known under Section 11(6). So like I told you, both the registrar and the courts can decide whether a mark is a well-known mark. So they can decide it concurrently, together at the same time. It depends on where the applicant wants to go. Then on the next slide, we have well-known status that provides protection against across different classes. Then prosecution history estoppel we just talked about. This is basically just a summary of everything we've just covered. Then on the next slide, we have some procedural developments that have taken place. Now, trademark infringement suits are recognized as commercial suits if they cross the threshold of their, involvement of the financial implications. So if it is more than 50 lakhs, the damages that you're seeking, then of course it is a commercial suit. And when it is a commercial suit, then there has to be a Section 12A pre-institution mediation that has to be mandatorily carried out. Of course, that is very technical. That is for you to study later on. It comes to it is important when you're practicing in courts to understand what is Section 12A of Commercial Codes Act. Why is mitigation mandatory before filing the suit? And if you want to forego the mediation process because there is an urgent relief that is being asked, then how to go about it, you have to understand by studying cases pertaining to Section 12A of Commercial Codes Act that are relevant to trademark law. Then pleadings and evidence. Courts have strictly enforced requirements for full disclosure of material facts, documentary evidence of use, turnover, advertising, proof of distinctiveness, evidence of confusion or damage in passing of or actions. Then interim relief standards. Interim relief is while the case is going on, in the meanwhile you can ask for injunction, a stay order, a restraining order. So for that, you'll have to prove there is a prima facie case in your favor, there is balance of convenience that if it is granted in your favor, it will not cause as much harm to the opposite party as it will cause to you if it is not granted. Then irreparable injury, that you will suffer irreparable injury if the person keeps on infringing your trademark. Then with additional consideration of delay and acquiescence. These are some um, emerging trends and some crossovers that you have to be careful about. On the next slide, we have what are the emerging trends. There are stricter scrutiny of well known claims, emphasis on honest adoption, protection of small businesses, integration of design and trademark protection. Now, on the last slide, we have practical takeaways that I hope that you're going to carry with you after the end of this session. That you must conduct comprehensive searches before trademark adoption. You must document everything very, very carefully. You must be consistent in your representation, that you're not saying one thing in your reply to examination report and the other in your counter statement to opposition. You have to be consistent. You have to monitor and enforce promptly. So you have to conduct trademark watch also. You have to exercise your rights. If you get a registration certificate, you have to be prompt. Then you have to consider territorial strategy, where it is easier to get your trademark or where you have more to lose, your client has more to lose, you apply there. So you are protected in that territory. Then you pursue well-known status proactively if there is a well-known mark. If your client has a well-known mark, then you pursue it. You decide depending on the case whether you have to apply directly to the registry or you want to go to courts. Then you have to maintain clean prosecution history, ensure representations to registrar are accurate and defensible in future litigation, explore alternative remedies where infringement claim is weak due to concurrent registration, focus on passing off based on prior use and goodwill, things like that. These are just indicative, illustrative, they're not comprehensive. So you have to apply, of course, your own minds. You have to create your own strategy. With this, we've come to the end of the session. We can proceed. Any questions or queries or any feedback that you guys may have pertaining to our session today, and anything you'd like to say, Varun?
Yes, if anyone has any question, please feel free to unmute yourself and ask from the speaker. We will take last 2 or 3 minutes. If you have any doubts, please ask within 2 or 3 minutes. You can type in the chat box. You can directly ask from the speaker by unmuting your mic, else we will end the session within 1 or 2 minutes. I think most of the participants do not have any doubt. Those who are present in the session, I request please you can personally ping me at WhatsApp. You guys will get your certificate of participations within 24 hours. And at the end, I would like to thank Sanya ma'am for the valuable time and teaching to the participants.
Thank you, Varun, and I hope that you are all carrying something with today after this session that will help you in your professional career. I'm always available. Varun has my details, so anybody who wants to reach out to me has any doubts can also approach me on LinkedIn or later have a chat with me and develop something that is valuable and useful to you in your career and adds to your personality as a lawyer. So I hope that you're able to do this, to further your career. And all the very best. Thank you for joining us on a Sunday. Have a great day,
Thank you.
everybody. Thank you.
Thank you very much. Thank you.
Mhm.